perfectly fine arguing law. I'm perfectly fine arguing procedure. I am not fine with personal attacks. What I don't expect is to get the treatment I'm getting right now from defense counsel based on being female. And that's exactly, I'm just going to call it out, that's exactly what it is. I highly doubt that any of my male colleagues from our office would have been treated the way I've been treated by defense counsel.
Court does call the case of the people, state of Michigan versus Cyrus Abadi.
Good afternoon, Your Honor. Mary Stanhouse, Assistant Prosecuting Attorney.
And good afternoon, Your Honor. With us on behalf of Cyrus Abadi, standing to me, right? Cyrus, please speak.
Good afternoon, Your Honor. Cyrus Abadi here.
All right, this has come back to me. I don't know if it's really a motion, but I don't know who would like to start, but I certainly have some questions.
I have a few things to put on the record, and I'll defer to Mr. Dowse if he wants to go first. I have no problem with that.
I do not need to go first. So.
Well, you might need to. I'm going to let you put on what you need to put on the record, because I think the last communication I saw, Mr. Dowse had filed something and you had requested whether or not we needed a written response or whether or not you could give an oral response. I think my staff had indicated what my answer was and that you could give an oral response on the record. So if that's where you'd like to start, go ahead, Mr.
That's correct, Your Honor, and thank you for the opportunity to do so. I actually don't know where to start. This is a unique situation. I've never been accused in a public filing of lying. I've never been told that my narrative is sanctionable. So I'm not sure exactly where to start. I will start.
Well, I've got some things to say about that, but go ahead. Because and Mr. Dowse, I'm just going to tell you, I don't expect attorneys to necessarily like each other. I don't even care whether they like each other. Whether they talk to each other is irrelevant to me unless they cannot communicate in some professional way. But as I've told other attorneys, and particularly, and I'll name him Mr. Bennett, when he came and he accused somebody of some type of misconduct, that when that statement is made, the court has to look at that. And so I made it very clear to him, and I'll make it clear to you. If those are the kinds of things that are going to happen, you better be ready to roll with it, and you better have it. Because if you don't, that's sanction. Ms. Tanner, you may proceed.
Your Honor, as counsel knows, and I think everyone in this room is aware, within this profession, our reputation and our integrity is everything. Throughout my career, I've routinely made decisions that were difficult decisions to make in a lot of aspects. I've been able to make those decisions because my reputation and my integrity are that important to me. Quite frankly, no case is worth me losing everything I've worked so hard for. What I've also routinely done in front of Your Honor, as well as other judges, is stand up here and make a point of defending opposing counsels when other people have accused them of anything from lying to misconduct and so on. The reason I make a point of doing that, even though in many situations that has truly not been necessary, is because I want to be very clear how important it is that we don't throw out baseless accusations at people. It's not a new situation to me necessarily to encounter a situation with opposing counsel where we disagree, where we misunderstand each other. I don't take offense. I've gone head to head with some of the best attorneys in this county as well as other counties. And not once have I been accused of what defense counsel is accusing me of. And what bothers me more is I actually started out respecting defense counsel a great deal. As far as I knew, we had a fine working relationship, and I had no reason to believe that anything changed. I think I in this situation, have been more patient, respectful, and understanding of this defense counsel than I would have been with a lot of other counsel for that reason, because we started out respecting each other. Obviously, we've had a point where that's changed. I'm not sure exactly why, and maybe counsel will enlighten us today, but he seems to have a personal problem. I am perfectly fine arguing law. I'm perfectly fine arguing procedure. I am not fine with personal attacks. Those personal attacks are not just in the written form in these public filings where I'm being accused of all kinds of things. They've also been verbal. They've also been contained in an email communication. I have an email, and quite frankly, Your Honor, I wasn't going to bring this up because I don't take personal offense. This field makes us develop very thick skin. And I don't anticipate in dealing with other people within this field for them to have thinner skin than I do. And perhaps that is my mistake, and I need to be more cautious and aware of people's hurt feelings and how it affects how they conduct themselves. I do want to put this on the record because I think it speaks to why we saw the reply that we saw. This is an email from September 25th of this year from Mr. Doust to myself. It's in response to a request he made, a reply I sent him, which again, we can certainly look at that, but this is the part I'm concerned about. Curious, you can articulate and posture all you want, Marie. Just don't think for a second that I'm not seeing right through you. I don't know what the intent of that email was. What I do know, it's not necessary for what was being discussed. What I know is that it's a personal attack. So I'll just leave it at that. I'll leave it at that. It's not lost on me that unfortunately we live in a society where people who are privileged in certain ways, and specifically being male, think that they can address female attorneys a certain way that differs from how they would address male attorneys. I do this job not expecting to be treated any differently than my male colleagues. I advocate just as strongly as my male colleagues do. Anything less than that would be ineffective. What I don't expect is to get the treatment I'm getting right now from defense counsel based on being female. And that's exactly, I'm just going to call it out, that's exactly what it is. I highly doubt that any of my male colleagues from our office would have been treated the way I've been treated by defense counsel. And even though I probably how it affects how they conduct themselves. I do want to put this on the record because I think it speaks to why we saw the reply that we saw.
The attacks have become personal. She says
she has an email from September 25th of this year from Mr. Doust to myself. It's in response to a request he made, a reply I sent him, which again, we can certainly look at that.
But this is
the part I'm concerned about.
Because the conflict is about to become much
curious. You can articulate. Shouldn't be shocked at this point, having done this job as long as I have. I truly am. Because in working with many different male, female counsels of all backgrounds, this is the first time it's risen to this level. And that's saying something. What's even more concerning to me is that it was done in a public filing. Now, I realize, and I've come to understand that defense counsel's feelings were hurt by what he seems to believe is attitude for me or my treatment of him. I have not treated him any differently than I would treat any other counsel. I've conducted myself in a professional manner when I could. There are times where we have very intense discussions, and that's not out of any kind of intent to offend anyone. I'm quite shocked that defense counsel is as offended as he is by me and the job I've been doing. I was also shocked to read what he wrote. My hope is, because I try to get...
Are you talking about what, and I don't mean to interrupt you, but you're talking about what he wrote in his response?
In the reply. Specifically in paragraph 5. My hope is that counsel's kind of passions and hurt feelings took over, and that logic and common sense just didn't catch up quick enough before he filed that reply. So with the court's permission, I'd like to offer him an opportunity to essentially withdraw paragraph 5 of his reply and ask the court to strike it from the public record. I think that's the appropriate thing to do. I'm not going to sit there and ask for an apology, but at the very least, that is what he could do to remedy the situation. And I do have serious concerns about his ability to efficiently represent his client when he seems to have such hurt feelings and such a personal problem with it. So that might be something he might want to consider. And I'm not going to discuss the case. That's something I appreciate the opportunity to put that on the record. I felt the need to defend myself. Judge Barr was present for a great deal of our conversation, actually all of our conversation in chambers. And I'll kind of leave it at that.
As to that issue, and I have great hesitation in saying this, and certainly Mr. Duss, you can respond if you want to that. When let me just say this before you respond. I've read over the years a number of your pleadings, both from you and both from those in your office. I'm trying to be careful in the way that I put this. What I read when I received that, I was surprised. Surprised, and I will say a little bit taken aback. Mainly because, and you know me, I'll just be blunt, I expected better from you. So, and I say that not with any thought as to how I would rule on this issue, because that wasn't really what was playing into my mind. Just expected better. Go ahead, Mr. Dobbs.
Thank you. This is not personal, Judge. This is professional.
Which part?
What I have put in writing and submitted to the court.
No, Mr. Doss. And I'll let you go on. But no, this was clearly personal. I have been reading briefs and preparing briefs, memorandums for over 30 some odd years. I've been reading them as a judge for over a quarter century. If I say to an attorney that I'm taken back by what you put in and that I expected better, you can take that however you will. You can defend yourself. You can say I'm all wrong, that I'm washed up, that somehow or another you can say whatever you want. But I don't say it unless I mean it.
Understood.
Go ahead.
Well, I'm an honest man. Ms. Tanner is quite skilled at doing one thing and then portraying it as something else. On September 23rd in chambers with Judge Bauer, she brought up a legal issue for which there is no support, no authority. We sought to have a conversation about that, and there was no conversation to be had with Ms. Tanner. And so the exam ended up being adjourned because Judge Barr at the moment was not in a position to decide any of this. The legal issue before the court is, there's no dispute that preliminary examinations are governed by statutes, court rules, and the Michigan Rules of Evidence. And under those rules, under MRE 4482C, defense counsel at exam at a CSC case may inquire about what is permitted within those rules. The proposition before the court is raised at the last occasion is that for defense counsel to elicit evidence under that rule at exam, there first has to be a motion and offer of proof. For that proposition, there's no authority whatsoever.
Okay, Mr. Doss, can I just stop you since you want to get into the substance of it? Let me just say, all the years I've been sitting on the bench, the rape shield statute has applied at preliminary examination. Because if it didn't, it frankly makes no sense. To say to someone, we afford you these protections from this intrusion into your life here, but we don't do it here, makes no sense. Because it's one of those things that once the cow has left the field, it's out. It's just there. And so it doesn't make any sense. Moreover, Mr. Doss, I was a bit surprised by it because your colleague, Mr. Shea, has argued the rape shield at preliminary examination, I believe on 2 occasions, but certainly one before me, and never indicated, never said whatsoever.
The tension continues as the
For that
attorney
proposition,
explains why the
there's no
accusations bother
authority
her so deeply.
whatsoever.
She says she has
Okay,
defended
Mr.
opposing
Doss, can I
counsel in
just
the
stop you
past,
since you
while
want
others
to get
made
into the
unsupported
substance of it?
allegations.
Let me just say,
Because reputation and integrity are everything in the legal profession.
all the years
But she
I've been
now
sitting
believes her
on the
relationship with
bench,
defense counsel has
the
completely
rape
changed.
shield statute
Then
has
she
applied
reveals
at
something
preliminary
even more
examination.
serious. According
Because
to
if
her,
it didn't,
the attacks were not
it
limited to
frankly
court
makes no
filings.
sense.
They also appeared in verbal exchanges
To
and
say to
emails.
someone,
One particular message becomes
we
a major
afford
point of
you
concern,
these
and she
protections
tells
from
the
this
judge that she
intrusion
believes the
into your
communication
life
crossed the
here,
line
but we
from legal
don't do it
argument into a
here,
personal
makes
attack.
no sense. That it does not apply at preliminary examination. Go ahead.
Well, the authority that there is on that issue is to the contrary. I believe it. I put it in writing. I provided the court with the authority. What in fact I did was I did not submit an advocacy piece. I did not. I'm not asking anything of the court. I'm not trying to convince the court of anything. I advised the court on what the law is. I believe I was well within the rules on going about it in that way. As far as now, what Ms. Tanner put on the record earlier, I understood, based on what the law is, that Ms. Tanner on September 23rd was taking an unsupported legal position and was, in a way, misinforming Judge Barr about it and was not having a conversation about it.
What, misinforming Judge Barr that the rape shield applied at preliminary examination?
Yes.
She would be taking a position that has been the longstanding practice in this county. How can you say that she's somehow just come out with something out of thin air? Show me one case, Mr. Dawson, in this county where rape shield has not been applied and not stood at preliminary examination.
The aspect that doesn't apply is the mechanism of a motion and offer of proof in MCL 750520J2. That aspect is just not applicable at this stage. It comes into play once the case is bound over. And that's the very issue that Ms. Tanner raised. She approached me asking whether I would elicit any testimony.
So, Mr. Das, you paint yourself into a corner. Because if that's the argument, then none of it comes out at prelim. Because the judge at prelim is the gatekeeper of all of that. And so what would actually end up happening is none of it would come in, ever. And then you go ahead and just make your argument in, circuit court.
Well, I understand we disagree on what the applicable law is on the issue. I did put it in writing. It is published.
Oh, but I'm talking about two different things, Mr. Das. I'm saying if you're indicating that the doctrine of rape shield and the protections that it's afford do not apply at prelim, then the judge, quite frankly, has the option of not hearing that testimony. Plain and simple. And then I just don't let it in. If I'm handling it, I don't let it in. And then you're going to have to deal with it as you want to deal with it in circuit court, which you won't get it in there.
If what the court describes were so, then the court would at that moment disallow the admission of relevant evidence under the court rules.
It's irrelevant. Somebody's past sexual history is irrelevant. I could just say that and I'm done.
Not with the defendant.
Pardon?
That's what the law said. That's what the court rule says, not with the defendant. That is not what the rule says. So, if I can go back once more. The very core item that's at issue is whether defense counsel before exam needs to provide a written motion and offer of proof if defense counsel wishes to inquire into evidence under 404A2C. And the law on that is that no, defense counsel is not required to do that. Defense counsel may inquire under the rule.
Okay.
Okay.
And if the judge says, I need a motion before you do it, what do you then answer?
I would ask the judge, what is the legal basis for making that requirement?
And the judge is going to say, because I said so.
I am hearing that, and yes, I am greatly at odds with it, because there's no legal basis.
Maybe that's the
for that
reason
requirement.
you wear the robe and you don't.
All right. I did submit in writing what I know the law to be, and I stand by that.
Anything additional, Mr.
At this point, Your Honor.
All right, this court is ready to rule so that there's an order that fashion Judge Barr can deal with. And that is that this court indeed does believe that the rape shield statutes were intended to offer certain protections to potential victims. That evidence, and this specifically needs to be noted, that evidence shall not be elicited at preliminary examination in any greater or lesser fashion, but in the same manner as that evidence would be alluded to at trial. To do otherwise would make the rape shield a nullity in its entirety. And so therefore, that evidence will not be allowed until such time as the court has had an opportunity to see what evidence is proffered at preliminary examination, is going to be proffered at preliminary examination. Tana, you will prepare the order. I will sign off, and that is the ruling of the court. Is there anything additional?
Moments like this show how courtroom decisions aren't just about rules. They're about judgment, patterns, and perception. So what do you think? Should the court allow more flexibility when there's no technical violation? Or is the judge right to stay cautious given the bigger picture? If
Opportunity to see what evidence is proffered at preliminary examination is going to be proffered.
She says she has
at
defended
preliminary
opposing counsel in the
examination.
past when others made unsupported allegations.
Tana, you will prepare the
Because
order.
reputation and integrity are
I
everything
will
in
sign
the legal
off,
profession.
and
But
that is
she
the
now
ruling of the
believes her
court.
relationship with defense counsel has completely
Is there
changed.
anything additional?
Then she reveals something even
moments
more
like
serious.
this show how
According to
courtroom
her,
decisions
The
aren't
attacks
just
were
about
not limited to
rules.
court filings.
They're about judgment.
They also appeared in
patterns,
verbal exchanges
and perception.
emails.
So what do you
One
think?
particular message
Should
becomes
the
a
court
major
allow
point of
more
concern.
flexibility when there's
And she
no
tells the
technical
judge that she
violation?
believed the
Or is
communication
the
crossed
judge
the
right
line
to stay
from legal
cautious given
argument
the
into
bigger
a
picture?
personal attack.